right. So our next file is People of the State of Michigan versus James Swiderski. This is actually a Missaukee County file. The case number is 24-3551 FH. Appearances from counsel, please.
Thank you, Your Honor. David Inhouse on behalf of the people.
Robert Hartel for Mr. Swidowski, who appears by Zoom, Your Honor.
Mr. Swidor, is it Swidowski or Swiderski?
Swiderski, Your Honor.
Thank you. Mr. Swiderski joins us today via Zoom. Also join us from the Missaukee County Courtroom via Zoom. Ms. Laura Odell, the probation officer on the file. We are here for an informal hearing on a probation violation. Back on February 4th of this year, which is only a couple of days ago, there was a request and summons for a probation violation, and an amended one was filed. Initially, the request and summons for a probation violation that was initially filed on January 21st of 2026 included 2 counts. Each count alleged a violation of probation for possession and use of alcohol. The added count included added count 3 and added count 4. Mr. Swiderski, I need to tell you that added count 3 alleges another violation of condition 2.0 and alleges that, which of course requires that you are not to use or possess alcoholic beverages or other intoxicants. It alleges that you used alcohol, on a different date. That was on December 5th. Added count 4 is that you possessed alcohol also on December 5th. So you've got 2 allegations. Counts 1 and 2 deal with December 15th, and added counts 3 and 4 also deal with December, but deal with the date of December 5th. So about 10 days apart. As to all 4 counts, again, you have the same rights, the right to challenge these at a contested hearing, have the prosecutor prove the allegations by preponderance of the evidence, question or cross-examine any witnesses against you. That have the right to present witnesses, evidence, or testimony if you chose to do so, as well as the right to remain silent and not have that silence used against you. All right, and you have the right to testify. And again, I will note that it looks like our original arraignment or show cause on the first summons was earlier this week on February 2nd. All right, Mr. Hartel, were you aware of the amended request and summons?
Yes, Your Honor, and I did discuss that with my client as well.
All right, thank you. Oh, and as a reminder, Mr. Swiderski, if you're found to be in violation of your probation, be resentenced on your original charge. That was possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Ms. Odell, it seems like have there been any other prior probation violations?
There have not, Your Honor.
Okay, all right, thank you. I'm sorry. For some reason, I thought there had been a written acknowledgement on one. Mr. Swiderski, then I need to tell you that of the 4 counts, they are all 4 technical accounts. However, even though they are 4, the law requires me to treat them underneath the same series of transactional events concept. So while there are 4, 2 deal with the same day of December 5th, and the other 2 deal with the same day of December 15th, which means as far as punishment goes or sentence goes, it's my understanding the most I could give the defendant would be up to 30 days. Does that make sense, Mr. Hartel?
It does, Your Honor.
Thank you. All right, what does your client wish to do, Mr. Hartel?
Your Honor, he's advised me that he would wish me to ask the court for a contested hearing.
All right, thank you very much. Mr. Swiderski, this will now be set for a contested hearing. Mr. Hartel, I'm not aware of any. Are there any new charges coming out of these anywhere? I don't know what the background is.
Not to my knowledge, no.
All right. Any issue then within the 14 days, which the first 14 days would have began on Monday, this past Monday, so it'll be next week. I've got at least a 3, if not a 4-day long trial. So it'll be in the following week. Or it might. Am I in Missaukee next week, Miss Odell? Next Friday? Or Miss
I don't believe so, Your Honor. The clerk is checking.
I'm checking.
All right. All right, hold on. Thank you.
You are not here.
Or-
You're gone next Friday. You're gone next Friday, Judge.
Yeah, I heard you. Am I going someplace fun?
I'm not sure.
It's okay, neither am I. So, all right, well, anyways. Maybe my wife had the staff put it on the calendar. All right, so anyways, Mr. Hartel, I don't want to kick it out a long time, but when the parties waived their 14-day, I'd only kick it out maybe to the next week.
After conferring with my client, we would be fine with the court sitting it out as far as the court
Yeah,
felt comfortable. He is amply employed, and just to err on the side of caution, in case he does have a finding and in case there is jail, he would like to be able to get his affairs in order. So more time would be preferred versus less time. Thank you.
Mr. Denham, that's up to you now.
Yeah, no, the people would also waive any time requirements. Next week I have a conference as well, so it would work out better for people as well.
Likely it's a Friday for me. I'm probably in Lansing. So, all right. Mr. Swiderski, what we're talking about now is setting this for a contested hearing. I want you to know that at a contested hearing, you can't appear via Zoom. I need to have you present, okay?
Yes, sir.
All right, thank you. The reason for that, so you understand it, is theoretically there could be a sentence if there's a finding of guilt, but also it becomes really difficult for you to sit there and converse with your attorney if you're not present. Hopefully that makes sense to you.
Yes, sir, it does.
All right, good enough. Thank you very much. Anything else, Mr. Herzog?
No, thank you.
Anything else, Mr. Denon? Bond hereby continues as previously set by this court. Again, these are requests and summons for probations, and we're dealing with offenses, and really there's only two. So, all right, we will see you here once the court sets it. Thank you very much. We are adjourned.
Yes, Your Honor, thank you.
All right, thanks. All right, we're on the record next, taking up this file, People of the State of Michigan versus Sean Michael Woodmansey. File number is 25-3639FH. Appearances from counsel, please.
Good morning, Your Honor. Thomas E. Evans appearing as Special Assistant Attorney General for the State of Michigan.
Thank you.
You're welcome.
Good morning, Allison Cass on behalf of Mr. Woodmansey, joined by Lisa Kirsch-Satawa.
Good morning,
you.
Your Honor. Lisa
Thank you, both
Kirsch-Satawa,
counsel.
also on behalf of Mr. Woodmansey.
All right, counsel appeared today via Zoom, and are they bringing them over, or is?
He's not in custody.
Oh. Well, we
Not on
don't have
PR,
Mr. Woodmansey.
I believe.
Now, this matter was scheduled today at 10:30. It's now 11:08. There is no one else in the courtroom other than a student who is job shadowing the prosecutor's office. So what do we have here? I don't think I've had any issues with him in the past, have I? Oh, wait, I modified his bond to PR bond on October 25th, but that doesn't seem to be of any issue. He hasn't had any bond issues since then. In fact, that's the last thing we have filed. Mr. Messer, what's your position on what to do? I can set it for a show cause. I don't have any.
Your Honor, sorry, I'm filling in for Ms. Messer, but
Oh, I'm sorry.
Your Honor, I would ask that a bench warrant or show cause be issued, and I'm not sure, unfortunately, what the conditions of pretrial release were. I would note that since the PR bond was granted on October 24th, not only has Mr. Woodmansey failed to appear here today, there have also been no payments.
Oh,
I don't know if that was a condition of the bond, but I'm sure the order still exists through the friend of the court, and there appears to be some contempt there as well.
well, let's take a look here. I think all he had, I think all there was is a condition of bond. Probably, it looks like it was set at the 25%. So that was posted. Let's take another look here at the file. Yeah, here we go. Yeah, there were no other special terms or conditions. Yeah, there wasn't any other term or condition that was listed. All right, counsel. Anything to say here today?
Yeah, so there have been efforts to reach out to Mr. Mancy regarding this today's hearing. I've been unsuccessful in this. We had multiple phone numbers on file for Mr. Woodmansey. In the past week, we've texted and called all of them out of an abundance of caution just to ensure that he got it. I also followed up with emails today and yesterday. Any texts prior to last Monday to Mr. Woodmansey would have been deleted. We were having phone issues and I lost all prior texts. So I'm not able to advise on what date he was advised of this prior. Yes, I've had no contact with Mr. Woodmansey regarding payments made.
All right, all right. All right, so the court's going to issue a bench warrant. The court will forfeit the defendant's bond that can be applied to his arrears for child support. And hopefully we'll get him. Right now, the court is, the trial date is still set for February 17th. If they are able to find I'm going to keep that trial date. But what I'll do is at probably next week, I'll adjourn it if we don't have them. So basically what I'm trying to do is we live in a small community. It's not like the big city folks here that are joining us from downstate. You might be walking down the street someplace. So if we are able to apprehend, if he's found, great, we'll keep it. But otherwise, I'll cancel it I'll probably put it on by Friday. I'll just say if we don't have them on Friday, we'll just adjourn the trial day. All right, hold on. My reasoning behind that is instead of having to set it for another final pretrial date, which means he could be sitting there for another month, because the next pretrial date would be March 4th. And if he were sitting there for a month, I don't know, if we can get him in, we can get it resolved earlier, then it works out to everybody's benefit, particularly his as well. So, but again, if we don't get them by Friday, then I'll adjourn it and have it set for another final pretrial, which means it will most likely be March 4th if we get them. All right.
Thank you, Your Honor. And if I might, as a possible preview of coming attractions, are there currently other trials set for February 17th?
I will let you know in 5 minutes. So the answer is, his case right now is the oldest.
Okay.
But it's only the oldest by 4 files, and we've got one more case coming up. So this is and Ms. Castle, I would like to assign it if you've never done it yet. You need to watch on YouTube Happy Days and look for when Fonzie jumps the shark, because then they do the to be continued. So right now we are to be continued, sir.
Thank you, Your Honor.
We'll find out if Fonzie makes it. Thank you. We're adjourned.
Thank you, Your Honor. Thank you, counsel.
Your Honor, do you have other matters this morning?
I have just one.
Okay. Can I address something on an unrelated matter before or after that one?
Yeah, well, we've got to bring over the defendant from the jail, right? Or no, he's coming, always on Zoom.
In Zoom.
Is he on there?
Yes.
All right. Mr. Powell, why don't you go ahead and just stay put, and I'll deal with this other one, and then I'll bring you in, and it will be off the record, and there won't be anybody in here by then.
Okay, thank you.
Yep. Again, we're adjourned. Then I'll bring you in. All right. Is he have video? There he is. Oh, that's right. We saw him earlier. All right. We are next taking up people of the state of Michigan versus Jeffrey Allen Peterson. The file number here is 25-3643FH. Appearances?
Thank you, David Denhout on behalf of the people.
Robert Hertzell from me, Mr. Peterson, who joins us by Zoom. I am filling in for Mr. Champion today, who's on vacation.
Thank you. Mr. Peterson joins us via Zoom. Sir, are you able to see and hear the court?
Yes, Your Honor.
Thank you. We're here today for a final pretrial conference in this case. Mr. Denham, what are we doing today?
Thank you, Your Honor. The people anticipate that there will be a plea in this case. The plea offer is that if the defendant pleads guilty to count one, that being possession of methamphetamine, that in exchange, the people will be dismissing both enhancements and both the subsequent notice as well as the habitual, I believe it was second notice. The anticipated guidelines that the people have calculated is 0 to 17 months here.
Gonna guess with it just being a have to, that would make sense. Mr. Hartel, is that a complete and accurate statement of the pretrial agreement as you understand it, sir?
As I understand it, based on the notes that Mr. Champion left in my conversations with him before he left, yes, Your Honor.
Mr. Peterson, is that how you wish to resolve today's file?
Yes, Your Honor.
I find that taking a plea today is appropriate via Zoom. It's complies with the court rules. Mr. Peterson, please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about, I figured that was the wrong hand, but that's all right. You figured it out. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. All right, Mr. Peterson, looking back on October 1st of 2025, were you on bond, probation, or parole at that time?
I was
which
on
one?
bond.
Okay. And for what were you on bond?
I was on bond for the possession of methamphetamine, this case.
In this?
Oh,
Okay.
oh, no. No, I was not, Your Honor.
I can see the confusion. I'm just going to ask the question again to make sure that neither one of us are confused. On that particular date, before you got caught by police, were you on probation, parole, or bond?
No, Your Honor.
Good. You are currently charged on a piece of paper called the felony information, in which you are charged with a single count and 2 sentencing enhancements. Count 1 is possession of the controlled substance methamphetamine. Now that is a felony punishable by up to 10 years and or up to $15,000. There are 2 potential sentencing enhancements that could be applied within the court's discretion. The first is called a second or subsequent drug offender enhancement. That could increase that maximum punishment from up to 10 years to up to 20 years, and from up to $15,000 up to $30,000. Or in the alternative, you could have been sentenced as a second habitual felony offender. Now that would increase that maximum punishment from up to 10 years to up to 15 years, and from up to $15,000 up to $27,500. However, if you plead guilty to that single count 1, the prosecutor agrees to dismiss the enhancements, which means you'll be pleading to a felony, which is a Class D felony, punishable by up to 10 years and or up to $15,000. Mr. Peterson, is that what you understood to be the terms of the pretrial agreement?
Yes, Your Honor.
All right. Now, by entering a plea today, you're not going to have a trial if I accept that plea. Does that make sense, Mr. Peterson?
Yes, Your Honor.
By pleading guilty, if I accept that plea, you will be given up certain rights. Now, that includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at a trial if you choose to testify. Sir, do you understand those rights?
Yes, sir.
And you understand that by pleading guilty, if I accept that plea, you'll be forever waiving those rights as they apply to this particular case.
Yeah, yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be by filing an application for leave to appeal and not an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Other than the terms of the agreement that I've already gone over with you, Mr. Peterson, have there been any other promises, threats, coercion, duress, guns to the head, anything like that to get you to plead guilty?
No, Your Honor.
Thank you. Are you entering the plea of your own free choice?
I am.
Now, Mr. Hartel or Mr. Champion has probably talked to you about the Michigan sentencing guidelines, which are applicable only in sentencings for felonies. They are not mandatory. They are, however, a tool the court must use, but the guideline range that they produce is not mandatory. Has anyone made a promise to you as to exactly what the sentence would be?
No, Your Honor.
Now, have you gone over all the terms of this agreement with your attorney?
I have.
Has he been able to answer all your questions for you in a satisfactory way that you understood them?
Yes.
All right, so far you were satisfied with his representation.
Yes.
Do you still wish therefore to enter the plea of guilty that we have just talked about?
I do, Your Honor.
As to count one, possession of the controlled substance methamphetamine, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention back to October 1st of 2025 in Forest Township here in Missaukee County. What happened that made you guilty of possession of methamphetamine?
I was I was in a traffic stop and I possessed methamphetamine on my person.
And where was it found on your person?
In my wallet.
And did you know that it was there?
I did.
And did you know that it was methamphetamine?
I did.
Now, when something's in a wallet, it makes me ask this question. Was it in like one of those little jeweler baggies or what was it in?
It was in a folded up piece of paper.
And so if you unfolded it, could you actually see it, maybe the residue or the powder or whatever?
Very clearly, yes.
All right, thank you. And again, you knew that it was methamphetamine, correct?
Yes, Your Honor.
And you didn't have any lawful reason to possess it?
No, I did not.
Mr. Denon, do you believe he's provided a factual basis?
Yes, sir.
We're gonna mix it up this time. Mr. Hartel, how about you?
I do too.
Mr. Denon, do you believe the court's compliance with parole 6.302?
Yes, sir.
Mr. Hartel?
Yes, sir.
And Mr. Denon, do you aware of any other promises, threats, or inducements?
I'm aware of none.
Mr. Hartel?
Nor am I.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required element for proof of count one. Therefore, the defendant is found guilty of count one, and the enhancements will be dismissed at the time of sentencing. Mr. Peterson's sentencing will be in about 4, maybe 5 weeks. Here in the courtroom, you must be present. Between now and then, an agent from the Michigan Department of Corrections, also known as the Probation or Parole Office, must prepare a pre-sentence investigation report. One of these reports must be prepared anytime someone is convicted of a felony in a state court here in Michigan. This report will describe the offense, the pretrial agreement, statements, information you make or provide, as well as make a recommendation as a sentence and a score into the guidelines. Please keep in mind it's only a recommendation, as this is my job to determine the sentence. And again, the guidelines are not mandatory. There are 3 steps involving you for the preparation of this report. Number 1, you're going to get contacted and you're going to communicate with the probation or parole office. They're going to give you a packet that you must complete and turn back in. Number 2, you'll be subject to an interview with an agent from that office. You have the right to have one of your 2 attorneys present during that interview. And number 3, your attorney must meet with you once this report is prepared prior to coming back to court. Why? Because each party has the right to come back to this court and request corrections or make objections to the scoring or the content contained therein. Do you understand that so far, Mr. Peterson?
Yes, Your Honor.
Now, Mr. Peterson, are you receiving treatment someplace?
I am at Harbor Hall in treatment. Yes.
Good. I'm going to make sure, I'm ordering to make sure that you comply with that treatment programming, okay? And as
Yes.
long as you do, and if you're still there, when it comes time for sentencing, I will adjourn sentencing because I want to make sure you get the benefit or the full benefit of that program. Okay, does it make sense?
Yes. Thank you, Your Honor.
Yeah, as long as you do well, your chances of staying out of jail go up. But if you leave and flee that program or give them the bird and run off, well, then we'll have you wear an orange jumpsuit for a while, but we're gonna talk positively. I know now that's gonna happen, Mr. Peterson. Anything further, Mr. Denon?
No, Your Honor.
Anything further, Mr. Hartel?
No, you are.
Bond is previously set by this court continues. Go back to your rehab. We'll see you all in a few weeks. Thank you.
Thank you.